Unit 3, dealing with institutions. We're going to be looking at the presidency in this lecture. It will probably be divided up into two different lectures. And so in this first lecture, we're going to talk about the election of the U.S. president, and then we'll begin talking about some of his powers, and then we'll continue on with that a little bit later in the second part. But the Americans elect their president very differently. It's a very bizarre system. And it is known as the Electoral College. And in Article 2 of the Constitution, it outlines that the United States will indirectly elect their president. And the reason that this is done is because the founders didn't really trust the people to be able to make an informed decision. And so it's sort of an indirect way where people have the ability to participate in the process, but they do not necessarily have a majority rule situation. And so it sort of plays out in a fascinating way, and we'll be looking at some of those situations in just a moment. But if you don't know how the Electoral College works, we're going to go over that first and foremost. There are 538 electors in the House of in the Electoral College, and each state is afforded the same number of electors as they have senators and House members, right? And so, if we were to look at some of the states, some states, every state has 2 senators. Every state has at least 1 House member. So you're guaranteed at least 3. Texas has 38 because we have 36 congressional districts, 2 senators. California has 55 because they have 53 congressional districts and 2 senators. But Alaska, interestingly enough, only has 3. It's a large state, but they have a very tiny population. So every state is going to be allotted a certain amount of electors, equal to the number of senators and House members that they have. And so that equals to 435. And then with the passage of the 23rd Amendment, the District of Columbia was given the ability to participate in this process, and they are given 3 electors. So what happens is a candidate needs to amass 270 of these 538 electors in order to get elected to the presidency. And so you need 270, and so by and large what we see is that candidates will create a strategy for which states they need to target and spend resources on in order to get to that magic number 270. Now, all of our states are going to be winner take all. So if your candidate wins the Electoral College, wins the popular vote in your state, they will receive your electors. Okay? Now, both political parties, the Republicans and the Democrats, they have their own set of electors, and these are people that will go on to cast the state's vote in the Electoral College for the individual that has won the majority in the state. And so they have their own slate of electors. And so if the Democrat wins in Texas, which hasn't happened in a while, but if the Democratic presidential nominee wins in Texas, then the Democratic slate of electors will go on to cast the votes in the Electoral College. If the Republican wins, then the Republican slate of electors will go on to to vote in the Electoral College. So if a candidate wins the popular vote in the states, their electors are selected, and it is a winner-take-all strategy. If you win the popular vote in Texas by 1 vote, you get all 38 of Texas's electoral votes. If you win the you win the popular vote in California, you get 55, right? So 48 states are going to be winner-take-all states, okay? Maine and Nebraska are two states that do things differently, and they divide up their electoral votes proportionately. So in a proportional fashion. So both candidates can win electoral votes in those states, but they don't have very many electoral votes in Nebraska and in Maine. So it's really relatively negligible, but it is not, they're not winner take all. And so once the popular vote occurs, each state, at each state level, then that candidate who wins the popular vote will get those electoral votes in that particular state. And we keep having this until somebody gets to 270 electoral votes. Okay? And then so after this occurs, after the election in November, the electors about a month later will officially elect the president in a meeting. Okay? And so there is no constitutional provision or federal law that actually requires electors to vote according to the results of the popular vote in their states. So theoretically, you could have some rogue electors who go and don't like the outcome of the election and might cast their vote for some random person in their political party. A lot of the times, these individuals will be ejected from the meeting, from the electoral process, and will be substituted in for somebody else. And some states require that electors, they have state laws that require electors to cast their votes according to the popular vote in the state. But anyway, the meeting of the electors takes place on the first Monday after the second Wednesday in December after the presidential election. And the electors meet in their respective states where they cast their votes for the president and vice president on separate ballots. Then in January, on January the 6th, Congress has already taken office on January the 3rd. There will be a joint session of Congress. And each state's electoral votes are counted in this joint session of Congress on the 6th of January. Following that meeting of electors, and the members of the House and the Senate meet in the House chamber to conduct the official tally of electoral votes. The vice president, whose role is the president of the Senate, will preside over the count, and they will announce the results of the vote. And so the president of the Senate, which is the vice president, then declares which persons, if any, have been elected to the presidency and the vice presidency of the United States, which makes for a little bit of an awkward situation, like in 2000 when Al Gore was the vice president and he had to make the announcement that his opponent had won the election, that George W. Bush had become the president. So it's a little bit, can become a little bit awkward. But the Electoral College provides that if there is no clear winner, if there's no person that gets 270 electoral votes, it provides for a method to decide. And what happens is the House of Representatives will decide the president, okay? And the vice president will be decided by the Senate. And so this has led to some fascinating history in America with the election of 1824. In the election of 1824, we had a four-way vote, a four-way election, and they were all part of the same political party, the Democratic Republicans. They were all in the same political party, and they were essentially vying for the presidency against one another. And so it pitted John Quincy Adams, Andrew Jackson, Henry Clay, and William H. Crawford against one another. No one got a majority of the vote. There was no clear majority. Jackson got 99 electoral votes, Adams got 84, Crawford got 41, and Clay got 37. And so with no clear majority, it went to the House of Representatives. And the top three vote getters are eligible to be considered when it goes to the House of Representatives. And so Clay, as the fourth place finisher, realized that he would get to decide which of the candidates he would support. And he was also Speaker of the House of Representatives, which is the chamber that would decide the presidency. And so what he does is he throws his support behind John Adams. And the reason that he does this is they have a 3-hour meeting prior to the House of Representatives deciding. In this meeting, they both say they did not discuss Clay's place in the presidential cabinet in this meeting, but it appears that they might have, because after the meeting and after the vote is taken in the House, Adams is going to win the vote in the House of Representatives, and he does so on the first round of voting. And this is largely thanks to Speaker Clay's support. He is very supportive of Adams. He hates Andrew Jackson, and he is throwing his support behind John Adams. And so after it's all said and done, Clay is offered and accepts the position of Secretary of State in the Adams administration. And so it looks like there was some backroom dealing going on, and it turns out that Clay leaves the House of Representatives and becomes the Secretary of State for John Adams. And the Secretary of State at that time in history is sort of a stepping stone to the presidency. And so this infuriates Jackson, and he goes on a 4-year tirade, essentially, calling this the corrupt bargain and vowing to get a little bit of retribution in regards to Adams. And so in the election of 1828, we're going to see Adams and Jackson be pitted against one another, and Jackson didn't have anything to do for 4 years except go around talking about this corrupt bargain, and we're going to see in 1828 that Jackson is going to be elected to the presidency overwhelmingly, defeating an incumbent president. So it just makes for some very fascinating politics with the Electoral College in a number of different ways, and this being one of them. Now, another way that it makes for some fascinating politics is that you can win the election without winning the popular vote, which really confounds a lot of people when they hear this, but it is possible, and it has happened 5 times in history. And the first time in history that it happened is in 1824, which we just spoke about. The second time in history that it happened is in 1876, when Rutherford B. Hayes defeated Samuel J. Tilden. Hayes won the election by 1 electoral vote, but he lost the popular vote by 250,000 votes. The third time it happened was in 1888 between Benjamin Harrison and Grover Cleveland. Harrison ends up with 233 electoral votes to Cleveland's 168 electoral votes, but Harrison will lose the popular vote by 90,000 votes. In 2000, George W. Bush will win the Electoral College with 271 electoral votes to Gore's 266, but he lost the popular vote by 540,000 popular votes. And then most recently in 2016, Donald Trump versus Hillary Clinton, Trump will receive 304 electoral votes to Clinton's 227, but he will lose the popular vote by some 2.9 million votes. So it is possible to win the Electoral College without winning the popular vote, and it has happened within our history. And so this gives a lot of fodder to individuals who are pro getting rid of or for getting rid of the Electoral College. A lot of people say it's antiquated and outdated and it needs to be gotten rid of. Well, there is a debate that rages between the benefits of the Electoral College and how harmful it potentially is, and this is one of those reasons that, or one of those pieces of evidence that people who do not support the Electoral College point to prove their point. And so when we elect the president, we elect an individual who has some constitutional requirements. The president must be 35 years old, the president must be a natural-born citizen, and he must have lived in the U.S. for 14 consecutive years prior to running for office. And so this this natural-born citizen question really cropped up in 2016 when Ted Cruz ran for the nomination for the Republican Party. He is an individual who was born to I believe, a Cuban father and an American mother, but they were living in Canada at the time of his birth, and so there was a lot of questions surrounding whether or not he was actually a natural born citizen, and they never really sort of hashed that out. Luckily, I mean, I don't know, luckily, but they decided, when he did not received the nomination for the Republican Party, that was an issue that they could kick down the road a little ways, and they wouldn't have to hash it out at this point. So you must be 35, a natural-born citizen, and have lived in the United States for 14 consecutive years. Okay, so we're going to start looking at presidential power. And Article 2 of the Constitution says that the executive power shall be vested in a president of the United States. And then sections 2 and 3 deal with the powers and the duties of the president. And so the president has a number of different categories of power. And the first category of powers that the president has are his expressed powers. And these are specifically defined powers granted to the president in the Constitution. So they are expressed, they are enumerated, they are in the Constitution, and the president has the ability to exercise these certain powers. There are also delegated powers. And delegated powers are constitutional powers that are assigned to one governmental agency, but that are exercised by another agency, with the express permission of the first. So in this situation, there are a lot of congressional powers that the legislative branch has that they simply do not have the time to execute. And so what they do is they delegate those powers to the executive branch and allow the executive branch to do that. And so we have another category here of powers that the president has, and they are given to him by the legislature. And then there are what are called the inherent powers. And these are not specified in the Constitution or the law, but, quote, "They are powers over and beyond those expressly granted in the Constitution or reasonably to be implied from express grants." And so what this means is that these are powers that have been expanded by former presidents and utilized by former presidents in the pursuit of executing the laws of the government. And so they might not be given to him by the Congress, they might not be given to him by the Constitution, but it's sort of like his elastic clause. It's sort of like his necessary and proper clause. He is able to utilize whatever powers necessary to carry out the laws of the United States, or according to some of those other powers that he is granted. And so we're going to look at each one of these individually. And so we'll look at the express powers first. And so if we look at expressed powers, there's going to be a breakdown of the express powers into multiple different categories. And the first is going to be the military powers. These are probably some of the most important powers exercised by the American president. The Constitution gives the president the power to be commander-in-chief, which is defined as the commander of the national military and state National Guard units. He is the highest military authority in the United States. He directs the Secretary of Defense, who heads up the Department of Defense. He directs the National Intelligence Network, which is made up of agencies like the CIA, the National Security Council, the National Security Agency, the FBI, and oftentimes, interestingly enough, the president is a civilian. He doesn't have any military background, and so he has to rely on what is known as the Joint Chiefs of Staff. And the Joint Chiefs of Staff is a council of 7 individuals that advises the President, the Secretary of Defense, the Homeland Security Council, and the National Security Council. And so the secretaries of the Joint Chiefs of Staff are a group of, like I said, 7 individuals made up of a chairman of the Joint Chiefs, a vice chairman of the Joint Chief, and then a military service chief from the Army, the Marine Corps, the Navy, the Army, and the chief of the National Guard Bureau. in which all of these individuals are appointed and confirmed by the Senate. So there is this council of military individuals that advise the president on military matters. And so you have some experts sort of playing into some of these military roles, these military decisions that are being made. The second type of category of express power are judicial powers. And judicial powers are the abilities to grant reprieves, grant pardons, grant amnesty. These can be used on behalf of a particular individual. One of the most famous uses of the judicial powers of the presidency were utilized by Gerald R. Ford, who granted a pardon to former President Richard Nixon following Nixon's resignation. Now, Nixon probably would have been indicted on something, but he saw the writing on the wall and he resigned. And when he resigned, he hadn't yet been indicted, but his vice president turned around and said, quote, "For all offenses against the United States which he has committed or may have committed," end quote, and he issued Richard Nixon a full pardon. Okay, so it's kind of maybe a little bit of an abuse of power. But there are some other instances in which presidents have utilized the judicial powers. Andrew Johnson is going to be the 17th president, and he will give full amnesty to all Southerners who had participated in the Civil War. So he is going to, as a way of trying to heal the nation and bring it back together, grant amnesty to those individuals who fought for the South. Jimmy Carter is going to give amnesty to all draft dodgers of the Vietnam War. He was the president in the late 70s after the Vietnam War was over, and so he is going to try to again heal the nation by providing those individuals with a full pardon or amnesty. Bill Clinton will pardon around 140 individuals in his last hours of office, and this is really not uncommon. Presidents in the last, they leave office on noon of January 20th, and so a lot of the times that last day in office they'll sign a flurry of pardons and reprieves and amnesty and things like that for certain individuals that they, I guess, deem fit for a pardon. George W. Bush is going to pardon Scooter Libby, who was Vice President Dick Cheney's chief of staff. And I don't know if you're old enough to remember, but there was a CIA issue called the Valerie Plame issue, where Scooter Libby had blown the cover of a CIA operative named Valerie Plame. Whatever the case, he was charged and convicted of that, and George W. Bush will turn around in the middle of his term of office and issue a pardon to Scooter Libby. George W. Bush is actually utilized the judicial powers to pardon fewer individuals than most other presidents do. Donald Trump has already exercised the pardon power with pardoning Joe Arpaio, who is the Arizona sheriff who was charged with criminal contempt of court after failing to do what a court had ordered him to do. That famous Arizona sheriff out there in Arizona. And so there's a lot of judicial power that surrounds the president. The president expressly has diplomatic power. The president is America's head of state, which means that he's the chief representative in dealing with other nations. And so he has the power to make treaties for the United States, although they must be ratified by the Senate. But because of this, he has the power to also recognize other countries' legitimacy. So he has the ability to enter into treaties, recognize the legitimacy of some nations, and because he sometimes wants to enter into an agreement or a treaty with other nations, but he knows the Senate won't pass a treaty, he will sometimes utilize what is known as the executive agreement. And an executive agreement is exactly like a treaty because it is a contract between two nations, but it does not require the approval of the Senate, and so it is sort of like an executive order. Only it's an executive agreement, and it's an agreement between the United States and another nation. The JCPOA, or the Iranian nuclear deal, was an executive agreement under President Obama, and presidents have increasingly used this power as time has progressed, because the Senate has become more partisan and less likely to ratify certain agreements or treaties that are entered into by a president. He also has executive express power, and Article 2, Section 3 stipulates that the president must see that all laws are faithfully executed, and this is going to play a big role when we get to those inherent powers a little bit later. It also provides that, or Section 2 provides that the president will appoint all executive officers and federal judges. Essentially, the president is the CEO of our country. He runs the country. He can be equated with our CEO. He also has some legislative powers, and there are two constitutional provisions that are primary legislative powers of the president. Article 2, Section 3 states, quote, "Presidents shall from time to time give Congress information on the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient." And so what this becomes is the State of the Union Address. And since FDR, presidents have utilized the State of the Union Address as an initiative to outline their legislative proposal. And so in the State of the Union, they will sort of tell Congress, here's what's going on, here's what I would like to see happen, and, you know, please put this legislation into place. And so you know, he has some power in shaping the legislation that might go through the House and the Senate and outlining it in the State of the Union Address. Article 1, Section 7, it's probably Article 2, Section 7, gives the president veto power, which prevents a bill from becoming a law. No, it could be Article 1. I'd have to go back and double check that. But Article 1, Section 7 gives the president veto power, which prevents a bill from becoming a law, and so he has the ability to veto a law that is passed by the legislative branch. The Constitution implies that the president has the power of legislative initiative, which can be defined as the president's implied power to bring a legislative agenda to Congress. And we see the president bring a legislative agenda to Congress all of the time. He outlines what he would like to see happen, and so there is some implications in the Constitution that sort of infer that he has this power. And then he also has legislative ability by using what is known as the executive order. And an executive order is a rule or regulation issued by the president that has the effect and formal status of laws. So that means, again, he can sort of go over the head of Congress, sign an executive order, and get something passed into law unilaterally, and it has the force of law. It's in power until it either expires, if there's an expiration date, or until another president comes in and undoes that particular executive order. And there have been examples of presidents utilizing the executive order all throughout history, and presidents do it more and more as we progress into our nation's history. Okay, so I'm going to stop our lecture here. When we come back, we're going to look at delegated powers, we're going to look at inherent powers, and then we're going to look at the resources the president has at his disposal. And so that will all be in part 2 of our next lecture. So stay tuned.